On a point of privilege.
Thank you, Mr. Speaker. I rise this afternoon on a question of privilege with respect to the response that was sent to my office to Q 1129 order paper question that I had submitted on the notice paper on March 23, 2015. This question is of great importance because it concerns my ability to undertake my work as a parliamentarian on behalf of my constituents, but also because it falls directly within my critic portfolio as the ethics, accountability, and transparency critic for the official opposition, because these are questions of legitimate government practice. At issue is the refusal of the government to answer a straightforward order paper question that was sent to me very strikingly by the member for Markham, who claimed that it was not government policy to answer any questions that had anything to do with court proceedings. As will be shown, Mr. Speaker, this answer is not credible and raises deep concerns because the specific questions that are asked, as shall be shown, are not subject to any court investigation right now, and in fact fall within the purview of parliamentarians in the House of Commons. The decision to refuse to answer an order paper question is about the potential interference in my ability to do my work as a parliamentarian. The question asks, with respect to each Senate appointment made by the Prime Minister, A, did the government verify that each individual being appointed to the Senate met their constitutional residency requirements? B, how did the government verify that each individual met their constitutional requirements? And C, what are the details verifying that each individual met their constitutional residency requirement? Now, these are straightforward questions that have been routinely evaded in the House, and we know from precedent, Mr. Speaker, that we're told that it's question period, not answer period, so the government can say whatever they want in evading straightforward questions about government practice. And yet, if this government has answered anything at all, they've been saying that the decisions regarding certain Senate appointments were done within the clear constitutional practice of 150 years. If that were the case, then it should be a fairly straightforward question to answer what those constitutional requirements are. What I think is important to point out, and this is where I will refer to the court proceedings, is we learned two things from the court proceedings. One is that the Crown Attorney in the Mike Duffy trial has said clearly that the issue of residency and the eligibility to sit in the Senate, is not a focus of the court proceedings. He made that clear on the first day. But he also, what we've learned from the court hearings, and this is why I will refer to the court once again, is that the issues of who decides residency, who decides the eligibility to sit in the Senate, it is a very arcane place, and it's been very difficult to get straight answers. But what we did learn in court is it is the role of the Prime Minister and the Privy Council. So these are issues that are germane to the House of Commons, is how decisions were made, why they were made, and whether or not there have been constitutional breaches by the appointments. This is an issue that we must deal with, Mr. Speaker, because we're talking about the constitutional requirements of this nation, which is the bedrock foundation of both legislative branches of government. And if there's issues being raised about the credibility of certain senators who may not be eligible to sit in the upper chamber, it will affect the credibility of all levels of government. So if the residency rules have been clear for 150 years, which says that each senator, quote, shall be resident in the province or territory that they represent, then there should be a practice that could be explained to the House of Commons through the order paper question process is how that verification happened. Because we know for Senator Duffy, he was appointed as Senator for Prince Edward Island, despite the fact that he lived in Ontario since 1971 with an Ontario driver's license, Ontario health card, Ontario tax payments, and passports claiming Ontario as his place of residence. So in vetting that appointment, did he meet the residency requirements? How was it done? What is the standard process? Those are questions that are not to be asked in the court hearing. They're not to be asked of the Senate because it's not within their purview. It's to be asked of the Prime Minister's office. Now, we have learned, I will mention one other element from the trial, and it needs to be mentioned, Mr. Speaker, because it raises my concern about why this answer wasn't given, in that what we heard from the court, and they're not investigating this because it's not within their purview, but that the Prime Minister's staff have identified a number of senators who may not meet the residency requirements. That if those names have been identified, and there have been apparently, from what we've seen of the email trees and that discussions about what problem that person gives, it raises once again whether or not the due diligence was done. We know, for example, Senator Wallen, who's facing charges now, was considered a resident of Toronto, yet was appointed to Saskatchewan. Senator Stuart Olson, who's appointed to represent New Brunswick, there's been questions that she should be considered an Ottawa senator. We learned from the RCMP that Nigel wrote that Senator Tkachuk's subcommittee is interviewing Senators Zimmer and Patterson. Why? I think they have qualification residency issues. Nigel Wright also wrote that I'm gravely concerned that Senator Duffy would be considered a resident of Ontario and possibly Senator Patterson in BC, but Senator Patterson was chosen to represent Nunavut. So, as he continues, as if they were adopted to the Senate's view of the constitutional requirements were met, the consequences are obvious. So we have learned that, so we should be learning from the government what due diligence they did to protect the integrity of our system. If red flags are being identified about senators, and it goes back to the choice of the Prime Minister here in choosing them, the Prime Minister's office needs to be able to explain what process was undertaken. Now, this is not the place, Mr. Speaker, to argue the various arguments back and forth, but I want to just clarify, because the government has claimed that it wasn't the responsibility of the Prime Minister, but the constitutional experts have told us otherwise. And we have, throughout the RCMP investigation and what we've seen from the court, is it has been brought back to the issue of the Prime Minister's office. So ensuring the integrity of that system becomes the job of members of Parliament, because we have to find out what is happening in the upper chamber if the Prime Minister was choosing to ignore the constitutional requirements, if his own staff had red flagged a number of senators for possibly being in contravention of the Constitution of this country. Therefore, on behalf of my constituents and for the benefit of all Canadians, I have used my parliamentary right to ask about that process that this Prime Minister has undertaken. Because if the basis of residency is so clear, then it should be a simple and easy definition for the government to be able to tell the Canadian public how the issues of residency are determined and who is eligible. Which brings me to the government's response to my question of May 8, 2015, which I will read in its entirety, which consists of 9 words. The government does not comment on matters before the court. Not only is that answer completely insufficient, it is completely incorrect, because the issue, as I had said at the beginning, of his residency ability to sit in the Senate has been determined by the court not to be the issue. The issue is 31 charges of fraud and breach of trust, which we do not deal with in this House, because that is a matter for the court. Nor are the questions in terms of certain Senate expenses that belong within the duties of the Senate, and I certainly hope they will do their job in cleaning up that place, but that is within their House. Within our House is the question that goes back to what the Prime Minister knew or did not know, and whether the Prime Minister has a process in place for ensuring the respect for the Constitution. So what I find also disturbing, Mr. Speaker, is that the answer to my question was signed by the member for Oak Ridge's Markham on behalf of the Prime Minister, a man who is day after day after day treated the House of Commons like a mockery because of the refusal to answer those straightforward questions. So I would ask you today, Mr. Speaker, to find that the wholesale avoidance by the government to a straightforward written question, 1129, and the misleading character of the answer constitutes a prima facie breach of my privileges as a member of this House. The responsibility of this matter lies solely with the Prime Minister, and the government needs to respect the rules that we have put in place for parliamentarians to do their job. Written questions are essential tools for Canadians. Through their elected representatives, we hold government to account, and none of the information that is in my questions seem to have been answered, could be found as somehow outside of our duties of Parliament. House of Commons Practice and Procedures 2nd edition lays out the intended purpose of written questions as the following at page 517, and I quote, "Written questions are placed after notice on the order paper with the intent of seeking from the Ministry detailed, lengthy or technical information relating to public affairs. It has been acknowledged somewhat universally in different sources, but in the Auditor General's November 2004 report that's entitled Process for Responding to Parliamentary Order Paper Questions, it says, the right to seek information and the right to hold government accountable are recognized as fundamental to our system of parliamentary government. Any attempt to interfere with the opposition's legitimate attempt to hold this government to account should be taken seriously, since this walks a very fine line of potentially contemptuous behavior for this House." And I hearken back to the 21st edition of Erskine May, which defines contempt as, quote, "an act or omission that obstructs or impedes either the House or one of its members in the performance of their functions is to be treated as contempt, even though there is no precedent for the offence." In this case, Mr. Speaker, it is the word omission that stands out there for me, and I believe that this needs to be answered. I'm asking you to look into this, because I believe if this precedent were allowed to stand for government to interfere in their responses to order paper questions and use the issue of they will not speak before matters of the court, it would be a ridiculous undermining of parliamentary tradition. And we just had the past week the government standing up over the Cotter incident that was before the courts and made it clear that they're more than willing to give their opinions when it's before the courts. So they are not respecting the precedents that they are setting, and they're using a court issue to deny us in the House of Commons our ability and our right to do our job. Thank you.